today? So, semua apa khabar?
Ya, doktor.
Alhamdulillah. Okay, can you hear me? Can not like same as last week. We have maybe on that day we have internet problem maybe, or line tak berapa okay last week. So I hope that for today we have a good connection, okay, so that we can manage to have our class clearly lah. Okay, you can hear my voice clearly. Right. So where do we stop? Last week, it's on the still on the chapter of liability for this week. Okay, I'm going to cover this chapter for 2 weeks. Okay, and last class, we stopped it at about the statutory law and common law. Okay, statutory law and common law, where the auditors liable to clients and also to third party under statutory law and common law. So under statutory law, I don't think that it will have any issue lah, because of it is a clear cut, okay, very easy for you, just read it. Whereby under statutory law, it is subject to the requirement of the Companies Act, okay, about the liability of the auditors, and then another few acts, okay, including of IA, Mafia, AMLA, and also Security Commission Act 1993. So it is a strict forward now when you're reading the statutory law, okay, statutory law with regards to the liability of the auditor. But under the common law, it's quite lengthy and few things that you have to understand. Okay, because it is subject to the cases. Okay, based on the cases that occurred previously, and have to refer to that cases that subject to the liability of auditor. Okay. So legal liability of the auditor. Okay, legal liability of auditor. I'm trying to refresh back about the chapter lah, about the legal liability. So legal liability of auditor is liable to the client and third party. Okay, so auditor is not only liable to the clients, that what we're going to discuss is, we know that of course lah, to the client when the auditor has been appointed as the auditor of the company, of the client, then if the auditor will be liable, okay, will be liable to the client, and there would be any possible legal liability that will be obliged to the auditor. Okay, this is from the part of the client. Okay, and another part is to the third parties. Okay, to the third parties. So the third parties are including the stakeholders as well. Okay, so the stakeholders, they are among the shareholders, the bankers, okay, the investors, the suppliers or creditors, as well as the government. Okay, will sue. Okay, they can sue auditor other than the client. Okay, the third party also can sue the auditor when the auditor not performing the engagement or service adequately. Okay, that's what the right of the clients and the auditor, the third parties to sue the auditor when the auditor not performing the engagement or the servicing adequately. Okay, so the auditor can be sued under the statutory law. Okay, I had mentioned before this. Okay, under the Companies Act, Security Act, Mafia Act, AMLA, Security Commission Act. Okay, that's under the statutory law. And another one is according or under the common law. So for the common law ni, okay, it is based on the case law. Okay, as I mentioned previously, it is based on the case law that developed by the judges from time to time. And the case law or the decision that made by the court is actually differently, okay, from time to time, whereby it depends on the situation, depends on the case, and also it depends on how the lawyer uh, providing or confirming that matters or ability to provide the prima facie to the judges upon the legal cases that occur. In other words, when we are talking about the lawyer that provide the prima facie or affirming the the judges, okay, it is not regarding to the case of the auditor only, but it is on the other law cases. Okay? It depends on the lawyer actually, because sometimes people, okay, he or she is just offended, but finally actually dia tak bersalah pun, cuma tertuduh. But finally when the lawyer able to provide the prima facie that he or she um, is has been allegedly and provide the prima facie for the allegation, then the person will be found guilty and um, they have been received the certainty by the order of the court lah. Okay, any other uh, either by depend on the case lah. So maksudnya sekarang ni yang saya nak bagi tahu maksudnya tugas lawyer lah. Okay, tugas lawyer they actually dia it's not purely nak cakap not purely uh, purely cakap they could be apa yang lawyer tu buat tu um, it's not totally clean and right. Okay, do you agree with me, class? Do you agree? Or any one of you among your family members work as the lawyer? Anyone? Your family members? Tak ada. For the kalau program syariah itu, it would not be in this case lah, for what I mentioned, for what I discussed. But for the civil cases, it could be yes. It could be yes because of as a lawyer, you could create any evidence that to confirm or to confirm to the judges that the defendant is doing that certain thing which has been alleged by the plaintiff lah. Okay, so same to these cases. Okay, into the cases of legal cases to the auditor. Okay, you can find that it will be differently. It's treat differently. Okay, as well as from time to time based on the decision that made by the judges at that time. Okay, nanti you akan nampak oh yang ni macam ni pula. Then another case, dia punya perbahasan discussion dia tu berbeza and come out to the different decision. to the auditor. Maksudnya yang issues ni adalah all the legal cases ataupun all that the auditor is being sued, okay, by the plaintiff lah, right? So under the common law, okay, case law is developed, or the judges, okay, provide the decision, okay, and it will be different from time to time, depending to the judges who issue the legal opinion from the cases that occurred, okay. However, sometimes the previous cases, and charges will be refer for the future cases that uh, that have the similar issues. Okay, so the previous cases or the previous charges will be referred for the future when we have the similar cases or issue that arise, okay, in the future. So under the common law, right? Under the common law, auditor will have liable to client for breach of contract and negligence, okay, negligence and fraud, and also not only to the client, okay, for what I had highlighted before, and also to the third party, okay, not only the client but to the third party for the negligence and fraud. Okay, so the application, okay, of the common law. So the common law is referring to all the legal cases that related to the auditor, class. So application of the common law to the third party is subjective. So subjective. That's why it depends on the decision by the judges at that time. That's why kat sini dia dah highlight it is subjective. So dia tak ada a concrete answer. This is definitely A, no. And this is definitely B, no. Okay, well, it depends on the situation as well as those who come out the decision. Depends on the judges, because that's why it highlighted it is subjective, inconsistent, all right, inconsistent, and depends on location and where the case held. Okay, and also it depends on the where and when, right? So kalau you pernah, memang you pernah lah kan, you had studied law before this, and sometimes the decision come out differently, depends on the cases, and this same to the legal cases against the auditor. So do you have any question? As for now, takut saya duduk bercakap seorang je. Any question? Do you have any question, class? So slide tu adalah referring to the previous slide yang I dah bagi tu lah. Sebab slide hari tu belum habis lagi. So you may refer yours, okay, from that slide, tapi saya tak buka slide pula. So you boleh refer the same slide as slide yang bagi I tu actually cover for 2 weeks lecture, right? So for this chapter ni dia more to the cases lah, okay, banyak cases yang you kena tahu apa finding from each cases and what are the issues in each of the cases. Okay, so now we look at the liability of auditor under common law. Okay, so cara lebih spesifik. Okay, liability of auditors under common law to client and the third parties. Okay, so the liability to clients due to the breach of contract. Okay, because we have the engagement letter. So auditor is subject to the engagement letter. So engagement letter is actually a contract lah. Okay, a contract between the auditor and the client. So if the auditor breached the contract, then there will be legal liability where the client can sue the auditor. And then the liability of auditor to the third party due to the negligence and fraud. Okay, however, okay, when the auditor, when the third party, they want to claim or sue the auditor, okay, they must provide proof, okay, must providing the proof so that barulah dia boleh katakan auditor tu memang bersalah lah ataupun negligence, okay, negligence or fraud performing their uh, task or their power as the auditor. Okay, so the among the few items or things that must be proved by the third party, okay, by the third party or the client, they want to prove that they must provide the proof that uh, that allowable for them to uh, bring any legal actions to the auditor. So we have four things, okay, four things or items that the client and auditor can apply this or provide this as the proof, right? So the first one is the duty of care. The auditor owed a duty of care to the plaintiff to conform to a required standard of care. Okay, so this is the thing that must be performed by the auditor. They must perform the task of the engagement with duty of care. And then the second one is breach of duty of care. Okay, daripada duty of care tu dah one of the issue, and another one, breach of duty of care. The auditor has failed to act in accordance with the duty of care to the plaintiff. Okay, the standard duty of care is that the reasonable skills and care of another person carried out the assignment. Okay, and the number three, the proof is causal relationship. There is causal relationship or connection between the auditor's negligence and the plaintiff plaintiff damage. And the last one is damages. The plaintiff is suffered actual loss or damages. So when the client and the third party court provide this, okay, the four of this item as the proof, then they can bring the any legal action to the auditors. Okay, if the client, okay, or the third party couldn't provide this uh, any of these four elements, okay, duty of care, breach of duty of care, causal relationship and damages, then um, the both parties, the client or either the third parties cannot sue or cannot provide any legal actions against the auditor. Okay. Next, we look at the auditor liability to client. The auditor liability to client in the case of the breach of the contract. So when auditor accept the engagement, okay, accept the engagement or the contract between the auditor and the client, so then it is there will be obligation, okay, there will be obligation of the auditor, okay, and the details of the obligation is stated in the engagement letter lah, right? So when the auditor, okay, couldn't perform the engagement, okay, couldn't perform the engagement, then auditor is liable, okay, is liable to the client for the breach of contract. Whether they tak perform or not perform properly the engagement, then the auditor is liable to client and due to the breach of contract or negligence. Okay, negligence. And therefore, okay, under the common law, auditor is required to perform his task with the due care. Okay, kalau dia tak perform the task with the due care, and there will be possibility that the auditor will be sued by the client. Okay. Okay, and next is on the auditor liability to clients and third party under the issue of the negligence. So what is actually negligence, guys? What is negligence? In a simple words, hello. Are you following me, class? Okay, please participate. When I'm asking you, so please lah, participate and try to throw your idea. Baik sudah kalau online class ni cakap seorang-seorang. Oh, tak boleh kena, you all tak boleh kena mic ke? Yes. Share your thoughts. Hello.
Yes, doctor.
Yes.
Negligence is kecuaian.
Kecuaian. Itu saja.
In general way lah.
In general, you define negligence itu adalah kecuaian, meaning that in this case is kecuaian of auditor tu lah.
Betul tak?
I'm not going to say right or wrong. So we are in discussion kan. So orang lain tak nak participate dalam kelas. Breach of duty. So nak cakap breach of duty of care lah ni. Okay. Tapi at least you participate. Maksudnya you are with me. Kan? You are with me. Bukannya you all ada kat pasar ke, kat mana-mana ke, you are with me. Salah tak apa, tak betul, tak apa, tak tepat pun tak apa. Okay, orang lain? So, kalau
Doctor,
okay.
failure to take proper care over something.
Failure to
Take proper care.
did proper care.
To take.
To what? To failure
Take.
to as written here lah.
Yes.
Right, alright. Okay, failure. So it's about the failure. It's about the careless. Okay. Okay. You for those who are participating through your idea. Okay, so we are discussing in relation to the common law. Okay, so negligence is it is a condition. Okay, it is a situation whereby a person suffer loss. Okay, ada seseorang tu yang ada suffer loss, okay, kerugian, which is it is due to another person's wrongful neglect. Okay, so to what we define the negligence, right? So I repeat again. So under the common law, the concept of negligence is a situation or condition that a person will have suffered loss. Okay, suffered loss for a certain amount due to the another person wrongful neglect. Okay. Okay. So as the third parties and the client, okay, client and the third party, they may claim the negligence, okay, when they could provide the following, okay. So the first one is an enforceable duty of care exists. Duty of care has been breached, and the third one is loss that resulted from the causal relationship between the auditor negligence and the plaintiff damage. Okay, so when they can prove following, then the clients or the third party can sue the auditor under the negligence. Okay, the negligence of the auditor to the clients and the third parties. Okay. So we are done on the breach of contract, negligence, and now we look at the next is on the duty of care to the third parties. Okay. Now kita nak tengok pada third party saja, bukan pada client. So kalau client dia punya right adalah breach of contract, okay, because there is engagement letter, okay, whereby the binding the contract between the auditor and the client. And then the next one under the concept or the matters of the negligence between both the third parties and as well as the clients, but by providing the following evidence, okay? And then the next we're going to look at the duty of care to the third parties. So under the common law, right? The common law, the third parties could bring the legal actions against the auditor under the tort and negligence. Okay, under the tort and the negligence. So what is tort? Okay, so the tort is the wrongful act or an infringement of a right. Okay, leading to the civil legal liability. So of course dalam law kita akan ada the law of tort. Okay, so dalam isu di sini kalau negligence tadi yang akan menyebabkan the third parties or another person incurred or suffer loss, and then kalau yang tort pula adalah wrongful act, sama ada sedar ataupun tak sedar, aware or unaware about this. Okay, so what I could give example here is the allegation of the misrepresented of financial statement and inaccurate audit reporting. Okay, so bila ada the plaintiff telah membuat pertuduhan, okay, plaintiff allegation the misrepresented financial statements, and hence they will lead to the inaccurate audit reporting that prepared by the auditor. So here, what will be the issue? Okay, the case, the situation is the misrepresented of the financial statement and provided inaccurate audit reports. Okay, and what will be the issue here? The third parties cannot easily prove that the auditor is negligence performing their task. So dia tak ada bukti lah. Kita tak ada bukti yang third party nak provide, yes, this is auditor is had misrepresented the financial statement. Tapi dia tak ada bukti yang betul-betul nak buat pertuduhan kepada auditor ni dah is actually negligence in performing their task or their duty. Okay, so here we have one of the case, okay, one of the auditor make them liable for their negligence of conduct, okay, when performing their task. So the case ni adalah nama dia Donna versus Stevenson, 1932. Okay, let me spell here. Dalam slide you ada kelas, dalam slide you slide number 56, okay. Donna versus Stevenson. Okay. Sorry, number 56, slide you. 56, 57, macam tu. Okay, Donna versus Stevenson, 1932. Okay, it established the precedence that a duty of care is owed to the third party. So, apa sebenarnya case Donna versus Stevenson ni? You all ada terjumpa tak? Ada terbaca ke? Saya dah tahu kan. Okay, so apa sebenarnya case ni? So Donna versus Stevenson 1932. I read you, okay, I read you the case. A woman, okay, the fact is a woman discovered the remains of a dead snail in a ginger beer bottle after consuming part of the contents, and as a result suffered physical and psychological injury. So itu adalah fact dia. Case dia adalah begitu. Itu mulanya case Jonah versus Stevenson 1932. Okay. So the main issue in this case was who could be held responsible for the woman's injury. Okay. So siapa yang will be liable dalam case ni? Will be responsible. So you following me class about the case? You listening to me Okay. So I repeat again, what are the facts? The fact is that a woman discovered the remains of a dead snail in a ginger beer bottle after consuming part of the contents, and as a result suffered physical and physiological injury. So the main issue in this case was who could be held responsible for the woman's injury. Alright? Okay. The retailer of the ginger beer could not be held liable for the contents of the ginger beer bottle as there was no contract between the woman and the retailer. The ginger beer had been bought by her friend, kawan dia yang beli, bought by her friend, and a contractual relationship and the resulting obligations and liabilities only existed between the friend and the retailer. Not the woman. Sebab kawan dia yang beli bagi kat dia. Yang suffer daripada case ni adalah the woman. Moreover, the remains of the dead snail found their way into the ginger beer bottle due to the negligence of the manufacturer, not the retailer. Kan, yang producer of the ginger beer. Then, however, the manufacturer also could not be sued in contract because the manufacturer had no contractual duty to the woman or to the consumer. So tak ada contractual duty yang exist di situ. Nevertheless, the court held the manufacturer liable in tort and said that, ini adalah keputusan daripada court The court held that the manufacturer liable in tort and said that the manufacturer owed the duty of care to the ultimate customer. So itu decision yang court bagi. The manufacturer owe the duty of care to the ultimate consumer. So in this case, even kawan pada woman tu yang beli kan, her friend, tapi the woman is the last, the ultimate consumer, then there is a duty of care owed by the manufacturer to the ultimate consumer. So di sini dia ada apply neighbor principle. Okay. So I read what is neighbor principle. So the rule that you are to love your neighbor becomes in law. You must not injure your neighbor, and the lawyer's question, who is my neighbor? You must take reasonable care to avoid acts or omissions which can reasonably foresee will be likely to injure your neighbor. Who then? The law say my neighbor. So the answer seems to be persons who are so closely and directly affected by my act, and I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called in question. So, even kalau kita tengok macam tak ada kaitan di situ, tetapi court provide the decision, the manufacturer is liable or owe the duty of care to the ultimate consumer. So, macam I cakap tadi, from this case, from this case of the Jonah versus Stevenson, it's applying the principle to professional, not only to the auditor, not only to the accountants and auditor, but to the other professional professional profession, making them liable for their negligent conduct where it resulted in financial injury to person to whom they owe the duty of care. Right? So when we're going to claiming, when we want to claim under this concept or the principle that providing from the case of Donald versus Stevenson, the position that stands today is that a person suing in negligence must satisfy the following criteria. Dia mesti memenuhi kriteria yang berikut lah untuk kita follow the decision from the case of Donald versus Stevenson. Okay, the first one is the claimant injury was foreseeable to the wrongdoing. So ada kewujudan di situ, maksudnya dalam kes woman ni dia as a claimant boleh dilihat lah by the manufacturer in this case. Okay, there was proximity of relationship between the wrongdoer and the claimant. So proximity in the relationship, maksudnya di situ the claimant as the user, okay, user of the products, and it is fair, just, and reasonable to impose liability to the wrongdoer. Okay, so that's from the cases that Stevenson, Donald versus Stevenson yang providing the decision or apa yang saya cakap tadi yang menyebabkan it is applied to the other professions including the accountants and auditor. So daripada situlah berlakunya another common law cases yang come out to the different decision lah. Yang pertamanya maksudnya duty of care tu adalah owed, okay, by the manufacturer to the ultimate consumer. So same goes to the concept in auditing in accountant. So the ultimate, dia bukan ultimate consumer lah, the ultimate users of the report adalah termasuk shareholders, banker, supplier, government, okay, dan lain-lain lagi lah. So maksudnya itu semua adalah the third parties, okay, even they are just the third party, but they also have right to sue the auditor, okay, applying the concept of Donald versus Stevenson. Okay. And then we continue balik pada yang tadi saya nak cakap pasal kes lain, tapi saya cerita dulu kes Donald versus Stevenson. Sebab dia adalah the key cases yang the key of the common law, key of the cases yang providing the other issue or other discussion and cases on the legal liabilities of the auditor. Okay, now I'm going to discuss with you about the doctrine of privity. Okay, so tadi kita discuss tentang duty of care to the third party. The third party dia tak boleh easily nak claim auditor ni bersalah ataupun they found the guilty or whatever unless dia boleh providing the proof of the negligence auditor. So now sebelum tu kita tengok doctrine of privity. Okay, what is the doctrine of privity ni sebenarnya? Okay, so doctrine of privity is doctrine of privity in the contract. Okay, so under the doctrine of privity, auditor had no liability to third parties who had no privity relationship with auditor. Okay, ini another doctrine lah, maksudnya berbeza dengan konsep dalam finding of the cases of Douglas tadi, not Douglas, Donald versus Stevenson. Okay, auditor had no liability to third parties who had no privity relationship with auditor. Itu maksud doctrine of privity. Maksudnya dia tak boleh nak mentadbirkanlah pada auditor tu sekiranya you are not have the privity relationship with auditor. Okay, macam saya cakap tadi, finding of the cases di common law ni dia berbeza-beza berdasarkan prinsip and the rules that apply in that decision. So kalau in case of the third party tu memang dia tak wujud lah privity relationship kan class. So sekarang ni kita akan ada exception daripada finding of the cases lah. Okay. Whereby we look at the cases of ultra mares, ultra mares versus Tosh et al. US 1931. So for this case, okay, ultra mares versus Tosh et al. 1931 is the first case that the third party looking for the damages from the auditor, whereby it actually occurred after the cases yang I mentioned tadi, Donnes versus Stevenson tu tahun 1926 kan? Ini 1931. Okay. So now we'll look at the case. Okay, Ultramaris, okay, had approved the loan, okay. Okay, dia dah approve the loan, when approached, okay. Maksudnya dia ada one of the borrowing company come to the Ultramaris, so maybe Ultramaris ni providing loan lah, okay, to all the person yang nak buat pinjaman wang, okay. Then they can come to the Ultramaris. So one of the borrowing company come to the Ultramaris to getting for the loan. Then the Ultramaris, okay, request to the borrowing company to provide the audited financial statement to maybe adalah yang apa yang dia nak review or look at the financial ability of the borrowing company lah. Okay. What happened? Okay, the Ultramaris approved the loan for the borrowing company yang datang pada dia untuk getting the loan. Okay, dia approved, and after getting the loan, the borrowing company become bankrupt. Okay, so in this case, the Ultramaris ataupun the plaintiff lah, okay, as a plaintiff alleged the auditor had been negligent in their audit, okay, whereby they unable to detect the irregularities, okay, on the accounting entries that had concealed borrowing company problem. Maksudnya dia menuduh lah, okay, menuduh that the auditor has been negligent, okay, in their audit, okay, and the auditor is a conceal other accounting information lah, okay, then that to show that the borrowing company is having problem. Okay, maksudnya itu pertuduhan the allegation of the Ultramaris to the auditor. Okay, and what the court said, okay, what is the decision provided by the courts? Okay, although the auditor were negligent in their audit, auditor not liable to third party. Okay, auditor not liable to third party because of the privity of the contract. Okay, because of the privity of the contract, and the third party was not deemed to be original parties or the primary beneficiaries of the contract. So ini under the doctrine of privity. That's why I mention tadi the punya doctrine of privity ni berbeza dengan finding or the result from the case of the Donnes tadi. Donat. Okay, Donat versus Stevenson. Because of this finding, Okay, the court order that the auditor will not be liable to the third parties because of the privity of the contract, and the third party was not deemed to be an original party or the primary beneficiaries of the contract. The primary beneficiary of the contract is the client, and not the third party. So itu daripada case yang kedua lah yang kita bincang in the class, Ultra Mares versus Toshi et al. However, in another cases of Hadley, Barney and Co versus Heller and Partners. Okay, Hadley, Bryan and Co versus Heller and Partners 1963. Dalam case ni, okay, case Hadley ni, dia tak apply lagi privity doctrine. Okay, privity doctrine no longer used to defend auditor to exclude the liability to third party. And starting from this case, okay, of Hadley and Bryan and Co and Heller Partners, okay, starting from this case, the number of the court decision have applied the extension of auditor liability to third party. Okay, so in the condition whereby the auditor, auditor tu tahu and who identify the third party who rely the auditor financial statement to make the decision, then the court established that the existence of a duty of care is exists here between the auditor and the third party. Right? Boleh faham ke kelas? So I'm not following dalam slide tu secara total I'm not following, tapi apa yang I discuss tu ada dalam slide tu. So sebab slide tu actually slide daripada our group lah. Okay, daripada our group, tapi dia ada dalam slide tu. Apa yang I cakap ni I discuss ada dalam slide. Tapi susunan in order yang I discuss daripada tadi, daripada awal kelas tu, dia I jumping mengikut a flow. Sebab slide tu nampak macam tak ada flow. Alright. Okay. Next. Next, we look at the extension of auditor liability to third party based on the proximity test. Jadi kita ada doctrine of privity. Yang ni pula the extension of auditor liability to third party based on the proximity test. So kita nak tengok berapa close, how long the close, okay, of the relationship between the auditors and the third party tu. So kalau kita boleh prove that there is from the proximity test, and kita boleh identify the level of the proximity, then kita boleh claim lah the auditor tu level. Okay, itu would be level. Okay, sometimes the auditor dia tak aware about the third party lah. Kita actually existed, okay, beyond the contract of the auditor and the client. But the court would use other tests such as proximity test based on the following. The first is primary beneficiary third party. The auditor knew the third party and the purpose of the audit is for the specific purpose of the identified third party. The second one is foreseen third party, the one that is known to or reasonably expected to be known to, then the auditor will rely on the auditor's work in making a particular business decision. And number 3 is the foreseeable third party, the users of audited financial statement who are not specially known to identified to the auditor, but who may reasonably be expected to see the financial statement and to make decision. Okay, so sekiranya dia boleh identify this according to the plausibility test, and then the auditor will be clean lah to the third party. Okay, so there we have a few cases in relation to this issue. Here. Jeb Fastener versus Mark Kapar Industry Private Limited versus Man and others. We have Royal Bank of Scotland and Benjamin Johnstone Mackley and others. So this is three of the different cases in relation to the issue on the extension of audited liability to third party based on pros and cons. Okay, so the case can be found in your slide kan, from slide Caparo, Royal Bank, okay. And then we have another thing here. Okay, the next is on the remedies. Okay, remedies. Okay. So remedies dalam textbook juga ada remedies, tapi you have to know about the dalam slide ada okay, about the remedies. Okay. So damages, damages seek to compensate the claimant company, okay, in monetary terms for any loss they have suffered as a result of the auditor's negligence. Okay, maksudnya di sini adalah compensation lah. So the contractual damages aims to compensate a party for its loss expectations or reliance costs, whereas tortious damages compensate the claimant for his foreseeable losses. As a general rule, the tort of negligence does not allow damages for all losses arising from negligent acts or omission. However, in the case of fraudulent misrepresentation, damages can be claimed in full for all losses suffered undertaken the tort of the state. Okay. Maksudnya, tak semua dia boleh claim compensation, but in case of the losses daripada fraudulent misrepresentation. Okay, fraudulent misrepresentation, it can be claimed in full. Okay. And then we have the contributory negligence. So yang kita mahu tadi pasal remedies and damages, dia hanya boleh, bukan semualah dia boleh claim, tapi kalau in case of fraudulent misrepresentation, dia boleh claim the full lah. The claimant can claim the full. And then for the contributory negligence, it is a defense that a negligent auditor can use to reduce its liability. Okay, ini yang auditor boleh buat. Okay, untuk mengurangkan dia punya liability. It occurs where the defendant auditor is not solely responsible for bringing about the claimant's losses. So as the auditor tu dia ada right jugalah yang mana to protect themselves ataupun untuk mengurangkan dia punya liability, whereby dia boleh raiskan that issue whereby dia bukan not the solely responsible, okay, for the losses that incurred by the claimants ataupun plaintiff lah. Okay, di sini the loss is caused partly by the claimant's failure to perform certain obligation and partly due to the auditor's negligence. So, dua-dua pihak lah, okay, boleh disampaikan ataupun menyebabkan berlakunya such an failure. Okay, where the claimant's losses suffer in this way, the claimant damages are reduced, taking into consideration his faults. So in this case, we have one of the common law case, cheat case. Okay, cheat case. Saya nak bagi contoh case Awa versus Daniels, Husky and Wells. Okay, so ini adalah case on the contributory negligence. So case ni panjang juga lah. So the case ni adalah on the one of the Australian company. Okay, about the negligence. Bagian saya tinggal case okay, last. Ada soalan? Do you have any questions?
The
Ada? So far, you had noted how many cases? Berapa case yang kita dah discuss? Berapa case? Dengarlah ni, saya tanya berapa case tak boleh nak beritahu. Saya tanya berapa case dah yang saya highlight from the discussion dalam kelas kita. Tak boleh bagi tahu berapa?
7.
7. Banyaknya. Yang saya discuss
3.
je kan. Yang I discuss 3 je. Yang I mention tu betul lah. Maybe betul lah yang 7. I discuss 3 bukan 2. 2 ni salah. Mesti tertidur tadi. Terus tanya kawan, apa 3 case yang highlight tadi? Okay, so how many of you in this class? 36 kan? Seven, 8 minus 2, 6. 6. So we have cases here. Bulan kelas saya ada nak assign new cases. Sini. Kejap ya kelas. Okay, class. Are you still with me?
Yes, doctor.
Alright. About the other cases, okay? Okay, we still have few of the cases yang kita tak cover, tapi I want these cases, okay, to be presented, by yours, okay. And this is the cases, okay, the other cases yang kita nak discuss, okay. And I want you to choose among yourself lah, among of these cases out of the 8. Maksudnya kita akan ada group yang ada 4, ada group yang ada 5. Am I right? Betul tak? Tak, saya nak tanya betul ke salah pun tak ada yang boleh jawab. But it was so hard for you to respond. Jadi untuk pemilihan group ni, I nak you yang decide lah. Okay, you yang decide. Then it depends on your creativity and how you're going to give this presentation, okay? You must have a video on this presentation on these cases lah. So, I tak nak video yang lama. So, memadai mencukupi lah. Okay, this enough that you could convey the facts, okay, and the information from the cases tu lah yang kita nak sampaikan, and kita boleh faham apa sebenarnya case tu dan dia ada kaitan dengan yang mana. Duty of care ke, duty whatever lah yang kita discuss tadi kan, ada few things yang kita bincang. So it depends on your creativity and maybe dalam just kalau bila kita buat video ni dia macam lagi informative dan kita boleh mudah faham kan. Video tak depends pada creativity tu. I tak nak limitkan macam mana bentuk you punya video presentation on these cases, but it depends on your creativity. Jadi kita akan discuss this before kita start our class next week kan. So kalau kita ada 8 video, kalau each video tu yang you nak presented tu 8 darab dengan 3 minit, so we only require about 30 minutes. So we still have time to discuss about our next chapter tu lah. Okay, next week kita akan ada new chapter. Jadi before our class start with the new chapter, kita nak highlightkan dulu, discuss dulu pasal bukan discuss, you punya presentation about these cases. So limit berapa minit? Limit hanya 3 minit pun saya rasa you boleh, kalau you buat video yang informatif tu. 3 minit ke 5 minit tu pun dah cukup. Okay, 3 to 5 minutes. Okay, saya assume that bila video ni dia lagi boleh jimat masa kan untuk you sampaikan. Okay, 3 to 5 minutes. So since you have 8 groups, so kita perlukan, kalau 3 minit, kita perlukan lebih kurang average of 30 minutes kan. So that kita continue dengan our new chapters lah, next class. So for this afternoon class, this evening, I provide you time for you to prepare for this video lah. Okay, so nanti in detail I akan letak instruction dalam klip lah. So this is among the cases. So you boleh pilih lah, you assign yourself mesti satu group satu cases lah. Okay, hanya 3 ke 5 minit dan akan present pada next class before kita masuk new chapter. Okay, so ada soalan yang tak jelas pasal video ni? video cases.
Jelas, Doktor.
So it should have the voices lah dalam video tu kan. Kalau ada suara. Bukan hanya buat video dengan apa gerakan presentation dan PowerPoint saja tak. You must have voices lah so that kita as a who watch the video boleh faham. Okay. So untuk petang ni macam biasalah. You have to log in the attendance and but then you may use this time for you to prepare this video. So jangan lupa you punya attendance tick dululah. Okay. So selain daripada pasal video ada soalan-soalan lain. And nama untuk peserta nama untuk setiap grup tu nanti saya nak lah. Okay. Memang tak ada soalan Tak ada soalan. Kita jumpa next week. If you have anything about this word, okay, you can ask me at Telegram. Okay, so ini nanti all the cases name nanti I akan letak dalam clip so that you boleh tengoklah in details dia punya tu tajuk nanti. And about the attendance ni hanya 33, no 32. So kita ada 36. Ada 4 orang yang tak hadir lah maksudnya. Okay, so thank you and see you again next week. Assalamualaikum.
Thank you, Doktor.